Well, good morning and welcome to the Great Transitions Senior Living Seminar Series. Great Transitions has been around since 2013, and I've had the privilege of hosting these seminars, for about 3 years now. And it's been a very fun and educational experience for me, and I hope for you all as well. We try to cover topics that will help seniors as they make decisions as their lifestyle and housing needs change. And so that means we're covering a wide variety of topics. It can be sometimes 12 to 18 months before someone is ready to make a move, or a life event can really expedite that process. One of our quotes today reminded me that Noah put his plan together pretty early, but it took about 120 years for him to execute it, right? So we want you to put your plan together so that no matter when you execute it, all you have to do is pull it off the shelf, right? And we're here to help guide you through the entire process, whatever your plan looks like. We genuinely believe that helping and guiding seniors is our greatest calling, and it's an honor and privilege to care for those that have cared for us for so many years. That's just the Great Transition Senior Living way. So today we cover topics: financial, medical, brain health. We've done travel seminars, but today we've got a legal topic to cover, and I'm super excited that we have two of my esteemed legal colleagues on our panel today. As we go through our questions and our discussion, I want you to keep in the back of your mind the challenge that we always make for you. Number one, who's going to be tasked with making decisions for you when you're no longer able to do so for yourself? And will you agree with the decisions that they make, right? And finally, once you've put your plan together, have you shared that plan with the people that are going to execute the plan for you, right? So just keep that in the back of your mind. We talk about making a plan at every single seminar. In fact, sometimes when I stand up here, I do feel a little bit like a broken record. But every day in our business, we are talking to people, and I know our educational partners same, that have not made a plan. And they are now making decisions in crises. And we want you to avoid that. So planning and making sure your life documents are complete and up to date is one important part of that plan. We always say not having a plan is a plan. It's just not a very good plan. So today we're going to unpack life documents and the things that surround those life documents. Many of you are homeowners, and so we're going to talk about some real estate related legal issues as well. Kind of an overview. Some of you may have some specific questions that relate to your particular situation. I encourage you to write them on your seminar notes page. We will have a Q&A time, and that's free legal advice. So I'm super excited about that. If it's a question that goes in depth, we may have to table it to a discussion outside of that, but we'll do the best to answer all the questions that we can. With that said, I'm going to ask our panelists to introduce themselves. Mary, hit the unmute button on your little microphone there. One more time. There you go. And tell us who you are and all about you.
Hello, everyone. I'm Mary Kaplan with Lighthouse Legal Group. You all met my partner a few minutes ago, Linda Solesh-Reed. Together, we practice estate planning, meaning wills, trusts, and these lifetime documents we're about to speak about. We also do probates, guardianships of both adults and minor children. And we do what we call elder law planning, which encompasses Medicaid planning and also kind of bleeds a little bit over into guardianship. So that's, all in all what we do. We do take pride in treating our clients like family. It's one of our firm values. Excellence and efficiency are our other two, and we try to stick with that in everything that we do.
Love that. Thank you. Mr. Roker.
Hi, I'm Paul Roker. I am currently General Counsel and Title Counsel with Innovative Title Services, something I started about 4 years ago. Prior to that, I was in private practice for 28 years in Florida, total for 41 years. I've been in practice. In my practice, I was a real estate lawyer representing primarily developers of both commercial, industrial, and residential properties. I'm really happy to be at Innovative Title Services, different focus, not dealing with problems or people with outrageous sums of money trying to destroy thousands of acres of Florida land, rather helping people sell or acquire their homes, which generally means people leave happy and are happy dealing with us.
Yeah, well, I'm glad to have you both here. You both have been a help to us, so I'm excited to hear what you have to unpack today. Mary, we're going to get started with you. Let's just do a quick overview of the lifetime documents and how they differ from end-of-life documents.
Okay, so this handy guide here will help you with what I'm about to tell you. So the basic life documents are, number one, durable power of attorney. Durable is important here. That means that the agent that you're appointing to deal with your financial decision making will be able to make these decisions for you starting the day you sign the document, because of course we never know what's going to happen to us in the next day, week, whatever. So and that's Florida law. It's effective upon signing. So from the day you sign the document all the way through any period of incapacity you may experience, whether that's temporary due to some accident or whether it's due to aging. If you become incapacitated, your agent will be able to continue making financial decisions for you, like bill paying and filing taxes, etc. The next on the list is what we call designation of healthcare surrogate. Other states call it advance directive or healthcare power of attorney, medical power of attorney. It all is the same thing. The concept is appointing a surrogate to make medical decisions for you. We recommend that you opt to make that effective immediately because, again, nobody has a crystal ball. We don't know when we're going to need someone to help us. There could be an accident that we don't anticipate, etc. But in that document, you appoint someone to make all medical decisions for you if you're ever unable to do so for yourself. Next, we have living will, not to be confused with will. So when people say will, they mean last will and testament, which is a different thing altogether, and it deals with distribution of assets after you pass away. Living will is only end-of-life medical decision making. So some people call it the pull the plug document. You want to pull the plug if you're ever determined to be end stage, vegetative state, coma, etc. And whatever your wishes are, you actually initial in what your wishes are in that document. And of course, we walk you through that document when you come into our office. And revocable living trust. This is not as much of a basic document, but it is I'm going to say it's a lifetime living document because unlike a will, it actually can help you and it has effect while you're still living. Wills are only effective when you die. That's why those are not living documents. A trust has effect the moment you sign it. And if you become incapacitated, again, as you age or maybe for some other reason, the successor trustee that you picked and you designated will be able to help you manage those assets that you have for your benefit and make decisions for you if you're ever unable to regarding those assets that are in the trust.
Okay, that's a great overview. Are there some common misconceptions that people have with some of these documents other than like living will versus will? I get that.
Yeah, so the biggest one is that revocable trust or any kind of trust is only for wealthy people. That's not the case. We have plenty of clients that do not consider themselves wealthy whatsoever that still wanted a trust because most people want to avoid probate in Florida. They don't want their family to have to go through probate, which is a court case, after they pass away. They want to make it smooth and easy for their family. So to avoid probate, that's usually the best solution to it is to set up this revocable trust. And it's only going to help you if you fund it, if you move assets into it while you're still living. And again, then the trust can do two things. It can help you avoid probate, help your family not have to deal with that whole mess after you're gone, but it can also help you while you're still living if you get to the point where you can't make decisions for yourself.
Okay. Paul, do you have anything to add to that?
The other thing I would add is that a revocable trust is everything that Mary said, but it also is not a catch-all to avoiding probate unless you have all your assets in it. If you put just your house, but you have other assets, then your family may still have to go through probate for the non-trust assets. So that's something to think about.
Okay, so we want to make sure that our home is in a revocable.
Either way.
Whatever.
Okay.
Depends if you're from the north
You
or the
say
south.
potato and I say potato. Revocable living trust. What's the process to go about that? And if my home gets put in the trust, what's the process for selling it?
Okay, the process is you start with Mary or a Mary because they are specific, they are a little complex, they are regulated by Florida statutes. So this is really something you need a lawyer for. I don't recommend going to LegalZoom and making a trust because you're only setting yourself and your family up for issues. You do a trust declaration or agreement, and then you decide what assets are going to be in it. If there's real estate assets, you will have to deed the real estate into the trust. Other assets, you would do whatever you need to do. If there's financial assets, you get with your financial planner and you transfer them to the trust. That's basically what it is. When you go to sell in Florida, it's not that much different from if you're selling it yourself, except we have something in Florida that's called legal ownership of the property in the trust and beneficial ownership. Legal ownership vests in the then current trustees, where beneficial ownership is the people you designate to be the beneficiaries of the trust. To sign all the documents and to be able to effectively transfer the real estate if you decide to sell it, you will need to have all the trustees sign those documents, then existing trustees. You'll need to have your original trust documents, which would be your agreement or declaration, any amendments you've made throughout the years to that, to have to your lawyer and ultimately to your title company so they can make sure the documents are prepared correctly and the title actually passes to your buyer. An interesting thing happened recently to a friend of mine at another title service, and that is property that was in a trust was sold, and the trustee directed all the proceeds into a personal account and not back into the trust. That's a major no. That can cause lots and lots of issues. So another process in setting up a trust is, and Mary and I were talking about this before we started, is to set up a trust bank account. Therefore, you have something that the legal entity owner of that bank account is the trust, so that as you may convert assets to cash, then that remains in the trust, and you don't get into the situation where we thought everything was in the trust and probate's taken care of, but oh, wait a minute, I just put $700,000 in a personal account that doesn't have a pay on death on it, so now my family has to probate that account. So it gets complicated, so be careful. Most financial institutions will allow you to open a bank account for a revocable trust using just your Social Security number. There are some banks that are peculiar about it and they want you to go out and get a separate taxpayer ID number for the trust. I do not recommend that because then you're getting into the realm of a more complicated trust that may have standalone assets and you don't have some of that pass-through abilities. Mary, your thoughts?
Yeah.
I just have a question. If I'm the trustee, or if it's my trust, and I have maybe two other trustees, I don't know, but I want to sell the house, do I have to get their permission?
Are the other trustees alternate trustees, so that in case you cannot act or you elect not to act and to give up your position as
So
trustee?
you can kind of
So it's
dictate.
it's then the then acting trustees at the time of the sale, whether it's 1 or 5, that have to sign the documents.
Okay,
Okay? If you have a trust, Beth, and then you go to sell a house, and on the trust documents, your son and his wife are your alternate or successor trustees in the event you decide to resign and not act, or you become incapacitated, or you hit the great speed bump at the end, then they become acting trustees and they would have to sign.
okay, so
But if
you
they're
can
just
determine,
Right, if they're successor or alternate trustees, they currently don't have the acting power under the statute
okay,
for the trust.
gotcha.
And most clients make themselves the trustee. And if it's a joint trust between spouses, then it's the 2 spouses are usually the trustees. Until, if and when they become incapacitated, then their alternates will step in at that point in time. But like he just said, the alternates don't have to sign off on anything. You and maybe your spouse are the only people that typically would have to sign anything while you're still living and healthy and
Got it.
have capacity.
Got it, okay. Let's jump back to power of attorney for a minute. Because I think we throw that term around a lot and maybe don't have complete understanding. I heard limited power of attorney. Does a POA include like dementia-specific provisions when you write it? Can they be added if need be?
So again, there's a difference between, I kind of touched on this a little bit, between power of attorney and durable power of attorney. We always draft durable powers of attorney for our clients because the whole goal usually is to cover you in case of incapacity in the future. So you don't, that's the durable part of it. It endures through any period of incapacity. So I'm sitting here today, mentally healthy, at least most people think that. Debatable, I guess.
I hope you are.
Yeah. I can sign my power of attorney, and then if in 30 years I develop dementia and I don't know how to pay my own bills anymore, my successor, my agent will step up. Right now it's my spouse. Maybe later I'll change it as my kids get older. They'll be my successor agents as well. But that's the whole point in my mind, is to make these powers of attorney durable, so they last throughout the time period if you ever do have dementia during that time period.
Okay. Paul, let's jump back to the house for a second.
Okay.
If I want a family member to help manage the sale of my home, what type of POA do I need to allow them to speak for me, and when should I get that all signed and done?
So, Mary talked about a durable power of attorney. Generally, on a durable power of attorney, one of the powers granted to the agent is the power to manage real estate, to buy, sell, mortgage it, rent it out. It's a broad grant of powers which would cover that person helping you with the sale of your home. Preferably, if we can do it, we prefer a limited power of attorney that is specific to just that property and just that sale. And it's usually limited in time. Usually you'll sign it about the time you want to go live, you want to sign a listing agreement, and then we generally make them maybe 4 to 6 months, and then they expire so that it's not out there forever and ever. And one of the reasons, not only if it's specific, we know you intended to allow this person to help you sell or buy this property, but when that happens, when we record the transfer deed, we have to record that power of attorney. This way, we put as limited information about you and all the things you have or you want somebody else to do, we can keep out of the public domain.
Love that. Love that. Paul, if I do become incapacitated, how do I make sure that my property taxes, my mortgage, all that stuff still gets paid? Because I don't want to lose my house.
This one's tough, and I'm going to ask Mary to help too, but this really comes down to having the right person to be your agent under a power of attorney or to be your successor trustee under a trust, because that person is the person who's ultimately going to control these things, manage your affairs, which includes paying mortgages and paying taxes.
Yeah.
I mean, we can't draft a document that is so ironclad that they have to pay, right?
Right. We want to add flexibility in our documents. I don't like directing a lot of things or requiring a lot of things, for people to do. A lot of people want to do specific dollar amounts, for example, to distribute dollar amounts specifically, to people every year. Now, that could work in some circumstances, but because of inflation and because of lack of knowledge about the future, I don't like to tie people down to all these super specific things in these documents. So again, you do need to really give it some thought about who would do the best job for you in this circumstance, and then name that person. And I understand a lot of people, maybe they don't have a spouse, maybe they don't have children either, or if they do, maybe the child isn't the best fit for this role. We do have professional fiduciaries that can serve in that role that we have worked with in the past and recommend. So don't think like, well, I don't have anybody, so I'm just not going to do it. There's always a workaround.
Well, and I think having access to someone like that is not something you want to do like in the moment. You need to, while everything's good, start investigating what that might look like, I would think, because the last thing you need is you're at the hospital at midnight and you need a POA.
And I've done that for people, and it's not ideal.
It's even less ideal when you are now in a care facility, a nursing home, and suddenly you need a power of attorney, and that puts Mary or me, whoever, in a position of, is this person really competent to sign a power of attorney at that point? And it gets very difficult. So that's definitely the wrong time, is when you're being admitted to that long-term care facility. That's the wrong time to be thinking about these kinds of documents.
Gotcha. Plan ahead. Okay, is there ever a time, so let's say I've set up all my documents, maybe I have a spouse or a child that I've named as POA, as health surrogate. Is there ever a time when I should remove that person, put somebody else in their place? If my spouse, and this one would probably go more to you, Paul, if the spouse develops dementia, should they be removed from the title of the home? So Mary, let's start with you.
So yes, there is a time where you may consider and probably should remove your spouse as agent under power of attorney or healthcare surrogate. I have a good example of that. And this seems obvious, of course, but we had a client who did her planning. She named her husband as her primary agent in the power of attorney, as well as her healthcare surrogate and the other documents. And then she did not have children, and she did not have close relationships with her siblings or really any other family. So she opted to name friends, one friend and then another friend as the first and second alternates in those documents. And that's fine, if you've got, there's no problem with that legally, and it could work. However, her husband then passed away, and then her friends both moved out of state, but she didn't come back in to update anything. Mm-hmm. So obviously, if somebody passes away, you're going to want to, change the document. That's number one. But number two, also, if people move out of state, the document, they can still act in that role. You can still be an agent under power of attorney if you live outside of the state of Florida. So you can name your child that lives in Georgia or wherever if you want to. But often, especially with friends that aren't family, it's harder. It's harder for them. It's a hard job. They may have to fly back here and go into the banks and maybe get in your safe deposit box or who knows what. Even though a lot of things can be done online these days, not everything can. So it's just something to think about. As life changes, of course, for all of us over time, things change. So you need to come back and revisit these documents if maybe your spouse is starting to decline. Maybe they're not officially, incapacitated, but they're starting to decline cognitively. It's probably better to act sooner rather than later to kind of update your documents. Or, of course, if your spouse or somebody else that you've named has passed away.
And I want to give you a real life situation that happened to my brother. My brother was married to a wonderful woman for 30 years, and then they decided to part ways. They got divorced. 2 years later, he got remarried and never thought about his documents. And 9 months after he got married, he was incapacitated in the hospital after a stroke, and his ex-wife was still his healthcare surrogate. Didn't sit well with the new wife, sat well with me because I trusted the 30-year-old wife who had children with him and still actually had some love for him than the new wife. But not a happy situation necessarily.
A little familial tension going on.
I was actually celebrating. Yes, it's not her.
know what he was.
Yeah, maybe he did.
Okay, well, let's talk a little bit more about some of those family kind of sticky situations. Mary, is there a lifetime document that we could choose what items to gift maybe our children or nieces and nephews as I downsize instead of after my passing in order to limit disagreements?
So we don't really have a lifetime document for that. I have some practical tips for that. So if we're talking about while you're still living, of course, we have other documents for this after you're deceased. But while you're still living, I've got clients who get creative and they do things like, okay, everybody, they'll put stickers, like different color-coded stickers on the back of certain items of personal property. And okay, the orange sticker, those all go to my daughter, and the blue sticker, that goes to my son, or what have you. Of course, you could just give, do whatever you want, have people come over and say, look, I'm trying to downsize, everybody can take what they want. And that's, of course, if people are getting along with each other. And if they're not, then that might not work. As far as after passing away, we have something called a separate writing memorandum to deal with smaller items, which usually are the items people end up bickering over after someone passes away. Things that might not have a lot of monetary value, but they do have sentimental value, like jewelry, furniture, et cetera, artwork that might have been done by a family member. Separate writings are great for that because you sit down on your own time and you basically write out this list of who gets what, specific items go to specific people. And if you don't do it, that's okay. It's just everything gets divided up between your beneficiaries and then they have to agree who gets what. So if you think that could be a problem, or even if you're not sure, it's good to do the separate writing because people then know they can look at this. Okay, mom wanted me to have this and she wanted you to have that. It really helps a lot.
Yeah. And then that person's gone, so you can blame them.
Right, well, that's what she said.
Yeah. But everybody's happy. Right.
Yeah.
There we go. Let's talk about someone who has dementia and it's progressed to a point where they're no longer making sound decisions. Maybe they're refusing home health or refusing to go to memory care or assisted living. Can their POA or their health surrogate override them, or do they have to be declared incapacitated in order to do so?
So that's a really great and very nuanced question. If your relative or whoever is actually refusing to do what they need to do in their own interest, like they're refusing to take medications or they're refusing to go into memory care, but yet they're wandering around on the streets when the sun goes down and they don't know where they are. No, you can't really stop them from doing those sorts of things with a power of attorney or a healthcare surrogate. When it comes to financials, this is another reason to have a revocable trust, because if you start making unsound decisions with your money, your successor trustee can then step up and help protect you against things like scammers. Maybe you're not making well-reasoned judgment with giving money away to people.
Yeah.
It happens a lot, unfortunately, especially down here. So your successor trustee can help manage those assets and help protect them against things like that if you have moved your accounts into the name of the trust, basically retitled bank accounts and things like that in the name of your trust. That is really where that can help you, but you can't really do that with a power of attorney or a healthcare surrogate. Now, one thing I wanted to kind of call back, I don't know if you guys remember me just talking a few minutes ago about the client we had who had named her husband followed by two friends and her power of attorney healthcare surrogate. Okay, so she did have a stroke, and this is why this all came up as an issue. And she, of course, nobody could do anything because in that case, no one was even authorized to do anything because, the husband was no longer living and the two friends said no, they declined to serve. They didn't want to serve in those roles.
You can do that?
Yeah, I've drafted declinations quite a few times for people to sign just to document, okay, you said you didn't want to sign, so the next person named can step up. But she didn't have another person named after those three people.
Wow.
So we did have to get her declared incapacitated as part of a guardianship court case that we had to open for her and get a guardian appointed over her.
Which is probably the last thing she wanted.
She hated every single minute of it because this was a perfect stranger. She didn't have any family. Because she'd had siblings, they lived out of state, but she wasn't close with them. And so we had to get a professional guardian name. We had no choice. Somebody had to get authorized to make medical and financial decisions. She had a house that needed to be managed, the lawn needed to be cut, her bills needed to be paid, and there was nobody with authority to do any of that. So she ended up with a professional guardian and hated every single minute of it. And I would hate it too. I understand that, but it's like a last resort. So this is why it's so important to have these documents we're talking about in place and have them updated over time as things change. So you have the right people named in those roles for you.
So Mary, let's look at the opposite situation. Let's say I have multiple children, 2, 3, 4 children. Can I just name them all and let them figure out?
I would not recommend that. I do have people ask me a lot about naming co-trustees or co-agents for the power of attorney. And if it's 2, I've done it, and I will do it if people insist. I do recommend not doing that though, because it just makes things harder for them and for you possibly, because depending on how you draft it, they both might need to agree on making these decisions, and sometimes they don't agree, and then what happens? No decision gets made. Or you could have drafted, I could draft it that they can act independently, but depending on the bank, sometimes the bank says, no, we don't care what you said. We want you both to come in and sign this document. Okay, so I can battle with their legal department, but in the meantime, nothing gets done. That happens more often than you would think. So I don't recommend naming multiple people together, especially more than 2. I would never name more than 2. It just makes things too difficult.
Gotcha, thank you. All right, this is a question we get a lot in our real estate practice, Paul, because we're dealing with people that are downsizing and decluttering a lot. When can I toss the documents I received from the closing of my home, and how do I determine that title is free and clear?
We generally go by what we call the 7-year rule, which is keep everything for 7 years. After that period, it's important to keep the original deed that you received, transferring the property to you, and your title insurance policy. Because if something ever happens during your ownership to the title and you need to make a title insurance claim, if you don't have the policy, chances are after 7 years, the title company that closed it for you, the mortgage company perhaps, even your broker may not have those documents, because after 7 years, systems now get purged, things get deleted. So those are the important ones to keep the originals of in a safe place. The best way to determine if title to your home is free and clear is to get a title search report done by a title insurance company, a title insurance closing agency like Innovative Title Services. Right now they cost about $85 depending upon the nature of the property. That's not a bad price for peace of mind. If you go to sell your home and Beth is your listing agent and we have a relationship, the minute she takes your listing, we don't wait till you're under contract to run the title search report and find out at that point there's something we have to clear. Beth immediately sends us that listing agreement and we run the title search report, and you will know immediately. And that's a very good practice. Not a lot of agents or title companies follow that practice, but I highly recommend it if you are trying to sell your home and you have any doubt about there being any liens or issues on the property. Get that report right away. Or even when you're contemplating, if you're talking to Beth about, hey, next spring I may want to list my house, Beth may say, well, let's start getting everything together. Let's get your trust documents. Let's run a title search report so that the package is ready for the day that Beth can take go live on your listing.
Gotcha. Thank you. Paul, if I've digitized everything, all of my legal documents, can I go ahead and shred the paper copies? And if not, like, which documents should I never shred?
For starters, your durable power of attorney, your trust every document that Mary put up there. Digital copies will not work in today's world, even in today's world. Those of you who have had any real estate closings recently, there are still only a limited number of documents when we get to the closing table that you can pre-sign digitally. Most documents still require what we call a wet signature in front of a notary who also puts a wet signature on it. So anything that talks about your ownership of something, anything that talks about how your affairs are to be handled, I would never, ever shred, even if you've digitized them. Mary, your thoughts?
Yeah, and I would add, that's especially true for last will and testament will. So parts of our legal system are still pretty antiquated. In my opinion, that's one of them. You must have the original will. You must have it and deposit it with the court within, the law says within 10 days of you learn, if you have possession of it, within 10 days of learning that the person is deceased. Now, that's not to say if the original can't be found, it does happen. There are steps you can take to prove the will, but that just runs up everybody's legal fees and just adds more time to try to track down witnesses and take oaths. And it's a whole complicated process. You can't just go to a notary. You got to get commissioner appointed by the court. It's quite complicated and adds a lot more time. And like I said, we, like all attorneys, we charge for our time in probates. And that's just going to create more costs and just more stress, people trying to tear around, find these original wills. So one thing that we always give people their original documents back. That's part of our practice. But one thing we've started doing the last few years is have our clients sign a receipt of original will that acknowledges they received it, and then just a one-line thing for them to fill in to say where they plan to keep and store that will, so that their family later can go find it. And if it's a document safe, that's actually, I love those at people's houses, any kind of safe, document safe, gun safe, whatever it is. But just make sure at least one person has the combination or the fingerprint besides you and your spouse so that they can get into it. It's just stuff like that people kind of forget about.
That's awesome. Thank you. Paul, we have people in here that have been in their homes 20 years, 30 years, 40 years, 50 years. Okay, maybe not, but quite a long time. How long should I keep that list of capital improvements that I made over the course of my ownership? And the follow-up to that is, what has to be disclosed when I go to sell my house?
For capital improvements, I would keep the records, just flat out, for many reasons. You have seen, Beth, we have seen houses that the seller's been in for 30 years. 25 years ago, they put an addition on, and now we run the title search report, lien search report, and we find out that the contractor never closed out that original permit. Didn't come back. Having those documents make it a lot easier to go to the city of Winter Park or Orange County and say, to the printing department, say, I'm in a pickle here. Here's the work. Here's where I paid for it. Here's the contractor. The contractor never got the final inspection, and so the permit is still open. What do I need to do? If you have those documents, it's pretty easy. You'll pay a re-inspection fee to the city or the county. They'll have those documents. They will come out and do the inspection and close your permit. If you don't have that paperwork, you're going to get a more detailed inspection from the city or the county inspector, and you may have issues where, well, what did the contractor do? Because I'm not seeing this, this, and this. 25 years later, you're trying to sell your house. Do you want to have a contractor out and have to redo it? No. So I recommend, it's a pain to keep paper documents, but hang on to them. When selling your house, on the disclosures is a good question. The Florida law says that anything that you believe or would affect the value of your property, you should disclose, with the caveat that anything that is either physically visible when a prospective buyer would walk through the house and they can see things that are obvious or are open, you don't have to disclose that.
So if I have a hole in my roof.
And you can look up and see the roof.
Yeah.
You don't need to say, hey,
Okay.
guess what, there's a hole in the roof. Anything that a home inspector should pick up on in doing a reasonably competent home inspection, you do not have to disclose. If the home inspector misses it, doesn't put it in their report, and the buyer's got an issue, their issue now is with their home inspector. Something that could not be readily discovered in those two ways, you need to disclose. Here's a good one. You had 3 years ago water intrusion into your house. You had to rip out all the drywall. You had to rip out insulation, clean out mold, replace and put the drywall back up. I can't tell that walking through the house because all I'm going to see is nice, pretty drywall. But there's something that happened behind that drywall. If there were termites behind that drywall that had to be retreated under the termite bond, those are things that are not readily discoverable, but yet you should be in your disclosure.
Gotcha. Thank you. Mary, the people that I name as my POA, as my healthcare surrogate, do they need copies of the documents?
Yes, that generally, yes. Of course, some people's situations are different.
And a paper copy?
But yes, I would give them a paper copy. You don't have to. No, digital copies are effective for powers of attorney, so that's okay. I mean, as long as people can print them out, you got to print them and take them to the bank usually. And sometimes you can upload them to, institutions like Fidelity, Vanguard, what have you. So you don't have to have multiple originals, although I do recommend holding on to your original. But I think it's always a good idea to give a copy to the first person that you've named in that document. And if you're married and it's your spouse that you're naming, then think about giving a copy to the first alternate after the two of you as well. I think it's a good idea.
Gotcha. All right, so kind of a wrap-up question for both of you. Which lifetime document do you consider to be the most important?
You want me to go?
Go.
Okay.
You're up.
So, of course, it depends on who you are and what your situation is. I would say the thing that comes to my mind first, because everybody over the age of 18 needs one, is the power of attorney and healthcare surrogate. It's hard to say which of those is more important because they're important for everybody. I made my kids, when they each turned 18, sign one so that if there was an accident or something, their father or I can make decisions. Same thing with power of attorney. I've actually had to use that for my son, who's now 21, to, help him out because he needed to get a debit card. Somebody needs to go pick it up. Just mundane things like that. You can't do that once your, kid turns 18 unless there's a power of attorney. So everybody needs those. And then I would say the revocable trust can be the most important document and is for the people who need it. So that would be people who have some savings, not super young people, but people that have some savings they worked hard for. The trust is the best way to protect you and your assets that you worked so hard your whole life to earn and save. Protects you against scammers and people who don't have your best interest in mind if you ever become incapacitated. And then it helps your family avoid probate after you pass away.
Paul?
I think that's comprehensive, yeah. I think Mary's right about stages of life. At different stages, one document may be more important than another.
So it's not necessarily a one and done, I'm good forever, I don't have to ever look at these documents again.
That is correct. I think that I like a 5-year rule. I think every 5 years you should revisit those documents, read them, make sure you understand them. And if you don't, you call Mary and say, Mary, I need a follow-up appointment for those documents you did 5 years ago because something's changed. My sister passed away and she's in all these documents, or I don't like my son's new wife, so I have some concerns, and I want to at least talk about them with you, Mary, before I go ahead and make changes.
Right.
But things change, and it's okay to question your son's new wife if that's appropriate, and to question all these decisions. It's okay. Your health conditions change, and maybe, when I first did those documents, I just made my oldest child everything. But now that I have these medical conditions, I'm more concerned about my son or my oldest child's emotional capacity to deal with some of the issues we're going to have to make. And I think my middle child is better to make those decisions and will be less guided by an emotional response and will make a rational decision.
Mm-hmm.
I love that because we change, but then those people that we've named, their situations change as well. And so there is that constant need to, not constant, but periodic need, I guess, to reevaluate. Awesome. I am sure that somebody has a question. And our educational partners, and Chris is stuck with the microphone, so can one of you that has done this before, so we won't make Chris do this. Robin, you can grab her microphone. And if you'd raise your hand and all right, let's see, Chris.
I was just gonna mention that beneficiaries on financial accounts are very important to have. You don't need to put them in a living trust or something like that if you do it.
Yeah, can you speak to beneficiaries on financial accounts and why that's important or may be important?
Yeah, and that can be a good idea. It depends on how much money is in that account. I often tell people to do that for smaller, like bill paying accounts. That way it keeps out of probate. You know, if you got a couple $1,000s or whatever it is in a checking account, you know, it's not like you want to let that money go, but it's maybe not worth opening a probate over. You don't want that to go through probate. Then yes, you can name what we call pay on death or transfer on death beneficiaries. However, do remember, if we're dealing with more than that amount of money, you know, if you go through incapacity, those pay on death beneficiaries are not going to help you at all. Those are only affected when you die. So if you need someone to help manage your money, protect you from, you know, what's going on, you know, scammers or people trying to take money from your account, maybe these were your friends, who knows? If you have that account in a trust, that trustee that you named to help you out can help you out and protect you and protect your assets and avoid what happened to my client, avoid guardianship of the property. Because guardianship of the property is basically appointing someone to manage all of your assets. And if you don't have a valid power of attorney, then you may end up in that if you become incapacitated.
Elaine, did you have a question?
Well, I
Right
think
here with you.
I think
We're fighting over the microphone.
I think that,
We both want to help.
I think Mary might have just answered my question. I was wondering about financial accounts that where the beneficiary is your trust,
Mhm.
that it's not titled in the trust. And so what happens during the
Okay,
lifetime?
so if
of
the
passing?
beneficiary on a financial account is your trust, but the account's not titled in the trust, how does that work?
Yeah, so you hit on the key. What happens during your lifetime? The answer is nothing. If I have a trust and it's empty and I have this account or several accounts that say pay on death to my trust, that's great for avoiding probate. It will successfully avoid probate. So that's good. But while you're alive, during your lifetime, again, if you end up, you know, not being able to manage your own money at some point because you've declined cognitively or you're incapacitated, that's doing nothing for you. And what are you going to, you know, there's a number of things. I could give you a bunch of worst case scenarios of things that have happened to people with, they've mistakenly given money away because they were fooled by some scam. You know, they're not 95 years old, whatever it is. And they don't have someone watching over that account. They don't have those in a trust. They can end up in guardianship. That's what usually happens when it gets real bad, if they've got advanced dementia and there's financial predators, and there's a lot of them, unfortunately, that I have direct experience with on, you know, dealing with in this state that are looking for vulnerable people to prey on.
Yeah.
So that is not going to help with any of that.
Gotcha. Oh, we got lots. Let's get through.
What are your thoughts on trust services with, you know, like Schwab, doing your trust services if you don't have a dependable person and you have a complicated estate? And also, if some of your trustees are getting close to 70 plus, that seems to be something to be considered.
So I think the question is, what about having a financial institution be your trustee?
Yeah, so, you know, that could work in the right situation. Just be aware of their fees. Ask for the fee schedule ahead of time because a lot of times they charge fees that are more than you would expect. Of course, you know, it can be a good backstop if you don't have trusted family or friends that you know would be there. And like you said, age is also something to think about. If you're naming people your own age, as you age, maybe you're better suited naming younger members of your family or, you know, an institution. We usually do that as a backup, but some people want to name them as primary. It's just to give it some thought. We also have individuals who are professional fiduciaries that we've worked with that we know are trustworthy people that we will recommend to clients if they ask us about that. And usually their fees are a little bit better, depending on, of course, the institution and the person.
Do you have anything to add to that, Dana?
But I love to reinforce that naming one generation younger than you is a great, just general rule of thumb for beneficiaries.
Great. I know we had some other questions up here, right there, okay.
If you place a property into a trust, does that have any effect on homestead exemption status?
That's a great
That's-
question. Is homestead exemption, Paul, why don't you take that? Is homestead exemption affected if your property goes into a trust?
The answer is it can be, but if you make yourself, you say you put it in a trust, you make yourself the trustee, and you're the first beneficiary, then the trust has to be structured properly with the homestead language in it, and the county property appraisers, most of them also have an affidavit you have to fill out. You fill out that affidavit, you bring them a copy of the trust, and then the homestead is continued once you go into trust. If you don't take that step, then, because technically on the property appraiser's database and website, title of the property has changed from you to the living trust of you, for example, is the name. So you need to make sure that the trust has the homestead provisions in it and that you follow through between January 1st and March 31st of the next tax year after you create the trust to reapply for the homestead. Any thoughts, Mary?
This is another reason not to do your trusts on LegalZoom. We include the homestead provisions that he's talking about in all of our revocable trusts. And we also include that language in the deed, the warranty deed that we draft to convey that property into the trust to make it doubly clear to the county that, yes, this is my homestead, it will continue to be my homestead, and I have a present right of possession in this home, which is what entitles me to continue to claim the homestead exemption. I've heard because we do draft them correctly, I've had very few people tell me that there's any kind of issue whatsoever. They're able to continue it. There's no reassessment. They continue to get that exemption every year.
There's no reassessment on your tax base
Hold on
either.
just a second. We're gonna bring the microphone around and we're gonna get to as many questions as we can. So we'll take this one and then we'll come to you.
What documents should everybody be assembling right now before meeting with you?
Oh, what
Before meeting with
documents,
me?
before we come to see you, what do we need?
That's a great question.
Yeah,
Great
great question. If you have pre-existing wills, trusts, other documents, you can upload those. We send you a link to our questionnaire website where you can upload documents. And then really the most important thing for you to fill out is our questionnaire. We have a very detailed questionnaire. Sometimes people don't fill out the whole thing, and it does make it harder for us because then I have to ask you all these basic questions during our first consult instead of knowing all that and kind of having a feel for it in advance.
So it's not just like I come and do it. I do need to do some prep, which is a great question. So thanks for asking that. To be ready, kind of like when you go to the doctor and you fill out all of that,
Yeah.
what's going on with your health and blah, blah, blah. Okay,
Yeah.
good. Dana or Robin, yeah, this gentleman, Frank?
Yeah, don't you avoid the whole trust issue when you have a ladybird deed?
Yeah, I actually,
That is
thank
gross.
you.
Oh.
I meant to talk about this.
Yeah.
I did too, because we had talked
Yeah.
about it.
So let's talk just real quickly about the life estate deed or the
The
ladybird deed.
enhanced life estate deed.
Enhanced
Or
life
or we affectionately call it ladybird deed in Florida because it was approved in a court case before the Florida Supreme Court with a party who was named Ladybird. That's how we got the name ladybird deed in Florida.
Good to know, thank you.
A ladybird deed, you take your property, or you and your spouse, and then we say, I'm taking my property and I'm giving it to my spouse and me, or to me, for the rest of my life, and then when I pass, for example, to my children, which avoids probate, it automatically passes, but you also reserve the right to do anything you want with the property. You can sell it, you can mortgage it, you can lien it, you can improve it, you can rent it out. However, you have a life estate deed and you become incapacitated. That does not give the people who are designated to take title upon your passing any ability or power to do anything to help you. It's a great, very efficient way to just avoid probate and make sure your property passes the people you want to. But everything else that Mary's talked about that are considerations in life documents, a Lady Bird deed does not get you there.
Okay, so it's good, but it's not complete.
Yeah, we do them quite often in the right situations, but it has to be the right situation. I get very nervous drafting those if you had more than, let's say you wanted to give the house to your children like most people do when they pass away. If you have more than 2 children, adding more and more people, like 3, 4, 5 people to receive this property increases the odds that something will happen that we don't want, which could be one of your kids predeceasing you, dying simultaneously. Unlikely, but it could happen. If these things happen, then we have to probate that person's estate. Maybe you avoided probate, but the person that's deceased, we have to probate their estate in order to clear title. And another thing to be aware of, this is not a legal thing, it's just a practical thing. So legally, yes, in Lady Bird deeds, if I'm the grantor, I am retaining the right to sell and the right to mortgage this property if I need to. But the trick is title companies at closing will almost always require that those remainder beneficiaries, like your children in that example, have to sign. They require them to sign the closing documents. So they have to agree with you that you can sell your home. They have to sign off and agree to that. And sometimes with family dynamics, they're not going to want to sign. They're mad at you for some reason.
So again, it could change over time, either your situation or their situation, so you want to keep that in mind.
Let me go one better.
Uh-oh.
And this just happened in the closing we just did. Lady Bird deed, 3 brothers and a sister inherited the property. After 18 months of 2 of the brothers paying the taxes, paying the HOA fees, maintaining the property, they said, we can't do this anymore, we want to sell it. Sister said, I refuse to sell it. It was Dad's house, and I will never sell Dad's house. They ended up in court in what's called a partition action, where the brothers actually had to sue their sister to say, we're partitioning ownership, or in this case, because you couldn't really partition and cut the house into pieces. If it were 10 acres and you had 4 kids, everybody gets 2.5 acres on new property lines. So they got a court-ordered sale of the property. The court appointed then a real estate broker as a special master who lists the property, sells it, signs all the closing documents. So on a Lady Bird deed, you ended up with somebody you didn't know controlling what happens between your children because they could not agree. So not a guardian, but it gets pretty close to being a guardian type situation. You have a third party who you don't know, never knew, now controlling. Even though you have probate, you've got a bigger mess. And that happens more often than you would think.
Okay, all right.
It's the other reason I-
Carl?
What about divorce papers to be given and set up, because there could be disputes in your will, and even if the divorce was in another country?
What are you asking? How?
I'm asking, should there be divorce records available so there are no disputes with your will?
Oh, okay, so do you need, that may be part of the questionnaire before I go get my documents drawn up.
Yeah, so if you mean if you're divorced or if your children get divorced later on,
The document that shows that you were divorced from your first wife.
yeah, I don't usually ask for those, but it could become an issue later, especially with sales of property and such. So yeah, you should hang on to those documents if that's what you're asking.
And if I can support the answer, just
Yes,
a little
please.
bit.
Yeah.
You know, any major life event is when we want to be reviewing our papers that we have. So a divorce, a death of a spouse, addition of children, or marriage of your children, them getting married, anything like that is a great time to read back through the documents, pay for an hour of legal advice, review, and see if changes are appropriate.
Okay, great. Flora has a question.
Would you be able to address agricultural land in another state? How would you handle it in this state?
Okay, so we've got some agricultural land in another state that we own. How does that get handled?
Well, I have had this issue before with clients, and usually their biggest concern If it isn't when they come in, it is when they leave, is, oh my gosh, if you leave this as is, you're going to end up with a probate in this other state, as well as possibly here if you don't do a trust. So usually we'll put a trust in place, like we taught, revocable trust, and then do a warranty deed to convey that property to the trust. So that's the very first thing, to avoid probate in 2 states potentially. That's a really bad scenario to be in. As far as handling, like the way it should be run, that's a different question. I don't, if that's what you meant.
No, I think you just.
Okay, yeah, so really, whenever I,
Put it in trust.
yes, to avoid the probate in that other state.
And I think that's what, at least in my personal situation with my parents' documents and my documents, is sitting down with your attorney. And I sat down with Linda a couple of years ago and was able to do this and just, here's my scenario. We walk through it and to determine, do I need a will and POD stuff or do I need a trust? Because the expense is different for both. And yet you want to be protected and you want your estate to be protected. So don't go to LegalZoom.
Please.
All right, we'll take one more question. Well, actually, Frank, you've already asked a question. Ed's got his hand up, so.
Yep, okay, hold on.
Yeah, if we'll do that, we try to do it one per person unless we have a lot of time.
Well, it's maybe a dumb question, but let's say I've got a trust in Florida and me and my wife both died, and then there's 2 children and they're out of state. Would they have to have probate if they're getting it, let's say they're in Kentucky and the trust is in Florida?
That's a good question. So where your trustees are, does where your trustees are matter if the trust is here in Florida?
No, where the people are doesn't matter. Where the property is what matters.
Okay,
So-
so, all right.
Yeah, if you've got, you can name people as trustees who live in other states.
Well, no, what I
Or
was really-
beneficiaries.
No, that wasn't quite what I meant.
Okay.
See, the point is, if you've got the trust in Florida, then would they have to have probate in their state? Or since it's coming from Florida in a trust, then they don't have to deal with probate in their state?
Does a trustee have to deal with probate in their own state once they?
If the property's owned by the trust, then no, there's no
No,
probate.
okay. That, all right, I'm good.
Yeah, that's,
All right. I know that there are other questions. Paul and Mary are not going to rush out the door before you leave. So if you want to ask a quick question, you can do that. But in the interest of time, I know that some of you have other places that you need to be. So we're going to wrap up. You can also choose to write questions on your blue form that you're going to give to either Nicole or one of the educational partners or me, and we can give you the follow-up answers to those. For those of you that are with us for the first time, we always ask, did we try to sell you anything? Awesome. But we want to ask you the more important question, and that is, what are you going to do with this information now that you have received it? Maybe all of your documents are perfect and you've just redone them and you're feeling really good about that, and I think that's awesome. Maybe it's been a little more than 5 years since you reviewed your documents. Maybe a family situation has changed. So I encourage you to think about what you might need to do. Don't forget, you're our connection to the world. We would love to have each of you invite somebody new to come to our seminar in August. Again, we're going to be talking about downsizing, right-sizing, all that fun stuff. Yeah, roll your eyes, Frank. I saw that. I saw that. And you can sign up for that seminar on your blue sheet. We'll see you on the 20th, and I hope to see you at Kelly's Ice Cream on the 26th. And maybe we might have the same favorite flavor. I don't know. Take a look at that. Thank you so much for coming, and we'll see you next month.